commands, press ** at any time during the conference. There are 9 participants in the conference.
The way we're pursuing this, we'll have some
Hey, everybody.
ammo to the water.
Hello.
Sorry.
Sorry I'm late today. I was trying to dig up some info to cover on the call with you today. And since it is a few minutes after 3, we'll go ahead and get started. And I recommend that everybody get a pen and some paper out because you're going to want to take some notes today. And if someone would, could everybody confirm that they got my email with the PDF
yes.
attached?
Second one came through.
Yeah, we got it.
Oh, good. Wonderful. Because that's what we're going to cover first. Next, before we get started on that, let me just say that we will also be covering the GSA forms again briefly today. I say briefly because what you're going to be looking at is a very narrow type of situation. We're still not comfortable with using GSA forms, principally because they're, at least with Forms 90 and 91, you're presenting yourself as a warranted contracting officer. And after we found Standard Form 1402, which is the appointment certificate for a warranted contracting officer, basically, my feeling about that was that despite Tony King's reassurance that it wasn't necessary, that I was not comfortable if somebody came to me and said, "Look, we're going to prosecute you for pretending to be a government official." In other words, impersonating a public official would be the charge. I would not be comfortable by saying, no, it's okay. Tony King said it was okay. I didn't need that form. So that's one of the reasons I've held off on using this. I have gotten feedback from several sources where these forms have been effective, and interestingly enough, the one arena where they've been most effective has been IRS. So we're planning on using these forms, and we're getting around the 1402 issue by using an administrative remedy which will grant you power of attorney, effectively doing for them, for the appropriate parties, the appointment and completing the certificate. That's mainly to cover your own rear end, and I think it's just simple prudence to do that. So we will briefly cover those. Hopefully, we'll get to those before the end of the call. For now, let's go ahead and review the materials that I sent to everyone. And just to give you a little background, there were 2 documents. One is the most important one is called Complete PKG, or Complete Package, if you like. And what it is a transcript of a call, and I guess we wouldn't even call it a call. It was an audio that was recorded between Jack Smith and this lady, Catherine, who has a group. And they have been experimenting along with other folks like us and yet many others, and have gotten some really good results with their money orders. And then, of course, as a result of that, have pretty much put together a step-by-step that they recommend. And just to let everybody know, I'm not proud. I'm not here to say, well, this is my idea, but rather I'm here to say, here's a good idea, whomever's idea it might be, and or here's a good track record. Because actually, since I've been in this movement for the last 12 years, I can honestly say that there's nobody who can claim sole possession of, the various approaches or paperwork or what have you that they're using, simply because we're all standing on the shoulders of giants and a lot of other people. All these things, the knowledge that we've acquired is really based on a multitude of researchers trying various approaches. Some work, some don't work, and of course over the period of time finding out stuff that, originally who would have ever suspected, but now we absolutely have confirmed a lot of this information, and consequently it's really quite powerful. And so why don't we go ahead, if everybody has the complete PKG or complete package PDF, I want to start out, interestingly enough, not with the first 8 pages. We'll come back to those in just a minute. I'd like to instead start off with page 51, which is a sample form wherein the party was getting, it says, urgent, we intend to levy on certain assets, please respond now. And this document was also sent to you as a JPEG separately, but let's go ahead and cover this. It's page 51 in your complete package PDF, if everybody has that. And I just want to go over, this is the kind of thing I actually like very much. Instead of getting simply a list of directions, which are also included here, I like the idea of, using actual samples or showing people what you're actually doing, and then, of course, commenting on it. So, for example, it says, accepted in return for assessed value and closure and settlement of this accounting by Anne Marie Martinelli, and then EIN, and then the number 123456789, and then, of course, authorized representative. Now, this is done in a computer script, and what is intended for you to know is that it should be handwritten. In other words, don't do it in computer script, but rather handwrite it in blue ink. That is the message where it says up at the top left in red, must be handwritten only in blue ink. It says put this statement on every page that came with your letter. Okay? And I just want to point out that the money order we're going to be covering and an acceptance for value are both bankers' acceptances. Okay? So scroll down a little bit so that you can see right below the paragraph that says our records indicate that you haven't paid the amount you owe, yada, yada. And there are 5 items that are listed in red, which are instructions. And it said, I'll just go over those real quick now. It says, do not detach the coupon from the page, leave it intact. Just to let you know, that is in direct contravention of other advice by other researchers who have been doing this for a while that suggests that yes, you should separate it, but send both in. This actually, in a way, makes a little more sense. If you're going to be sending both in, why separate it? Number 2, on the backs of each page that is blank, write on them, see reverse. And then 3, go over every single page to make sure everything is done right. That's an excellent idea. It's been my observance that everybody rushes way too much. And the reason that everyone rushes is they're paying attention to that furiously spinning wheel, which is your emotion saying, hurry up, hurry up, hurry up, got to get this done, got to go. You need to shut that voice up, and you need to calm way down, and you need to be very patient and make damn sure everything's right. Anyhow, we've had a number of experiences with people who are very, very frustrated, and the principal reason they're frustrated is they made a bunch of mistakes that could have been avoided, and, it just led to one bad thing after another. So it does pay to slow down and actually be very careful. Number 4, fold all the pages and put them back in the same envelope they came in so address shows in the window. 5, include the 1040V voucher page. Do not send the instructions. Now, there is in this package a sample 1040V voucher page, so you can see what that looks like. And then it suggests that you listen to the audio 10 times, which, of course, is actually a transcript at this point, so you can actually read the transcript. And that's a little easier because I like transcripts better than audios for something like this, principally because you can go right to the important stuff and read that over and over and over until you get it. And then the blah, blah, blah stuff, you can pretty much just read through for understanding, and you don't have to belabor the same stuff over and over again, but rather just stick with the really important stuff. Scroll down to the bottom of that page, and it says money order written again in blue ink. And it has pay to, also written in blue ink, United States Treasury, $8,500 and no cents. And actually, that should be $8,500 and no cents. That would be more correct. And then it says, of course, by Anne Marie Martinelli, EIN number.
No dollars, RJ. You're paying units.
Okay, fine. The point is, FRNs are called dollars, okay? That's not to make them dollars, but that's what they're called. And if we're talking about cents, then we can talk about dollars. Cents are these round copper things. See, but that's real money, whereas the so-called dollar is not. So, I suppose you could do this instead of saying 8,500 and no cents. You could simply say 85,000 cents. Anyhow, and then of course the page right after that is a simple thing that says write this on the back of any blank pages, see reverse. Now, what's so different from what we've been doing? And the answer is that this individual, Catherine, and her group strongly advocate doing everything in handwriting, that they've had far, far better results when, instead of using some kind of a stamp or imprint or printout, when it's done like it's shown here in blue ink with handwriting. So I would not ignore that. I think that's a valuable contribution, especially considering the fact that they've had good results with this. Let's go scroll back up to the top, and let's just cover some of the issues that she has discovered in the course of doing her research and trying various things. First off, she wants to make it clear that she is not the guru that has all the answers, and she points out in the first item that is highlighted that, they've had difficulties processing certain approaches, but what she has had good results with is, in fact, the money order. So she says here, so it seems like if you can get the zero, if you are working on a specific year, and you can get the zero coupon, it seems like you're done. Scroll down, that's page 1, and we want to cover everything that's highlighted, and obviously you're going to want to read this yourself. I don't want to read everything over the phone, that's silly, but I strongly advocate that everybody read this transcript in its entirety, because you'll get a lot better feeling for what Catherine and her group are doing and what we're recommending that you consider doing. Okay? So, at the bottom of page 1, Catherine's saying, we've seen letters that actually say the tax year is paid in full. We've also seen just processing that comes with a payment coupon with a zero balance for the year that's referenced. So they're saying no payment is due. We've got people who have never seen anything after that zero coupon for 7 months. So it seems that if you get the zero, if you're working on a specific year, and she does recommend doing everything specifically, by the way, as you will see, she says it looks like you're done. Now, let me make that clear when I say specifically. You'll notice that it was $8,500. It was not $10,000. It was not $100,000 or $1 million, which has been the strong suggestion in the past. What they are doing, in point of fact, is they are doing an actual acceptance of the amount demanded. So whenever they're writing the money order, they're writing it precisely for the amount required. Now, the fallout on this, and this does come out in the course of the call, is, gee, what if you're now, for whatever reason, say, X months have passed, and you're now past that amount and they're assessing additional interest? And her feeling is it's better to satisfy what's there and then go ahead and satisfy later, the loose change that's left over due to that extra couple of months. If you'll scroll down a little bit on that page, the next page, page 2, there are a few other things that we need to address. The most important one, of course, is, she says, so we'll see if I've got a guy now who just asked for a bunch of bills, and he's willing to call them up and say, hey, get the lien out of there, but we just keep working on. But we are seeing a 45 to 60-day processing time on those payments to IRS. Now, the reason that this is important, and it's really helpful to get this kind of feedback, is that people frequently react too quickly, and they're trying one thing, and if it doesn't instantly work, they're trying something else. And basically what they really are doing is throwing crap against the wall and hoping something sticks. And what Catherine's group is doing, contrary to that, is they're taking a far more precise approach. The other thing that they're doing that has to be highly commended is they're being very professional in the sense that they're not just trying this, trying that, just throwing stuff against the wall, but are actually staying on top of things. And I can note that all of the people that I've talked to, these people know other people who have had success in this regard. Without exception, all of them have been on top of their process like white on rice. So that's one of the things, one of the hallmarks of Catherine's group is that they are being precise and they are staying on top of their stuff and they're not letting things slip through the cracks. Okay, we're now at the top of page 3. And here it says, other than that, if you just send them a money order and they show the account at 0, then theoretically you've got evidence that the account has been settled. Then you don't really need to go to protest because the 0 on your documentation is the equivalent of a receipt. Now, a couple of things there. The most important one being the word evidence. And of course, as you all know, because you've heard this before, even if you do get something from them that could be construed as evidence, it's far better to do a short affidavit explaining what you've done, when you did it, when you sent in the money order, etc., and so forth, and then reference the receipt showing it's 0 and then writing it to the public record. That's evidence. Okay, so see, and also that gives them an opportunity to dispute, and of course they're not going to because they're constantly, IRS is notorious for dropping balls and just letting things slide, for months and months. So we're virtually never concerned that they're going to respond on something like that. All right, further down on the page, she says, I'm sure the stuff was crossing in the mail. The other thing is, we're only doing money orders on the coupons, on the payment voucher coupons that already have the routing numbers at the bottom. And that's important. In previous money orders where we've been instructing people to use the coupon, the numbers at the bottom is what she's referencing as routing numbers. They're actually not routing numbers because it's not a conventional banking type of situation, but it's very similar to a routing number on a bank because it tells the IRS internally what this is all about. In other words, it's a voucher. And you got to understand, again, that a voucher coupon, according to Black's, is money. So if you look up the word money in Black's Law Dictionary, one of those definitions is coupon. And of course, we all know that there is no money, and so that's why that's so important. Okay? All right. Once again, let me just say, because we don't have a lot of time here, and I'm hoping to get to the other materials and also cover them today, that I'm not going to be reading through all of this. I only want to hit the highlights, and I'm asking you instead to read through all of this. Don't skip that. Actually read it all. It is a transcript from a call that I listened to. Anyhow, A little further down, she says, even with the money orders that we do them for the exact amount of the bill, the exact amount. We're not doing double, we're not doing triple, and we're not doing quadruple. If it's a $5,000 frivolous filing, which we get because we experiment, if it's $5,000 even. If somebody doesn't pay their $5,000 on time, I think the penalties and interest come out to $5,032.19. So we're sending them $5,032.19. So we're doing the exact amount. We're not monkeying around with, and she goes on and explains more about that. I think that's a novel approach, and I like that. And the reason I like it is when you do an acceptance, what you're doing is you're turning that document, which was a bill, into money, hence the word money order. So effectively, considering the fact that even Federal Reserve notes, all so-called money today is through commercial instruments, you have to understand that when you do an acceptance for value or write money order on their coupon, you're literally turning that coupon into the equivalent of today's money. Okay? And that could be a very good reason why sticking with the exact amount and not doing the other approach, double, triple, whatever, is actually the smart way to go, and probably one of the reasons why Catherine and her group are doing well with this and getting very good results. Okay? Next item is page 4, and there's a couple of items, and we're just going to go ahead and read this through because most of it's highlighted anyhow. It says, write out another money order on the coupon and send them $11 and be consistent in your actions. All she's saying there is if you do, in fact, write it out for $5,000 and they hit you later for an extra bill, just do another money order. She goes on to say, I don't believe it all for 5 seconds in sending some crazy amount like $10 million. Out of all the people that I personally know that are dealing with stuff, one guy owes maybe $2.5 million. Most people do not owe the IRS $10 million. Question from Pete. Question is, are you using letter rogatories and negative averments and the whole package of other paperwork with the stuff you're sending along? She goes on to say, no. All we send, we take the top portion and accept it for value. You put the money order on the actual coupon, refold it so that it fits back in the IRS envelope, and send that. And we do a 1040V with it. Now, by the way, just to let everybody know, the 1040V is like mandatory. And the reason is the IRS is a bureaucracy. And when you're sending back the equivalent of today's cash, which is a commercial instrument, then you need to account for it. And that's the reason for the 1040V. All bureaucrats have their little way of operating, and if you don't cater to their method of operation, you're just begging for them to misplace, misdirect, or screw up what you're trying to do. So you actually do have to pay attention to what they're requesting. All right. So that's on the 1040V. So she goes on to say, you do not detach the coupon from the statement. That's a question. No. We literally just refold it so that you know in the payment window it's going in the mail to wherever the bill came from. If it's Andover or Fresno or Ogden or wherever, we refold it so that it fits right in the window, and we use their same envelope. We send it certified mail. Some people do it insured. Insured is kind of fun because then the post office is your witness. And actually, I would go past kind of fun. That's not a bad idea at all. But she says, usually just certified for the most part. Okay. Question from a participant. Why wouldn't you send them double the amount? Let's go ahead and read this. It says, if it goes back to what you're trying to accomplish, are you trying to zero the account? So if you send them, if your frivolous filing is $5,000 and you send them $7,500, how are you zeroing the account? Just take the current bill, and if you get a frivolous filing, they're sending you bills relatively regularly, usually at least every couple of months. Actually, it's more frequent than that. Here's your updated penalties and interest. If you are in bankruptcy, ask for a copy of any actual bills that they've received from the IRS and they should be able to give you a copy that's going to have the coupon at the bottom. That's a good piece of information to know. And it's going to have the routing numbers on it and all the strange things that seem to make it work. I want to insert here that we've had good results simply getting a hold of a taxpayer advocate. You have to plead your case. You have to basically beg them to help you. But once you get them on your team and get them agreeing to basically check things out or find out what's what, you can actually get these people to, get the folks in the know to go ahead and send you another coupon. Anyhow, continuing, she says, even though there is a dotted line to detach the coupon from the statement, do not detach it. And here's another little tip, too, is we never send a blank page to anybody anywhere. That's why she's putting C reverse on all blank pages where there's something on the other side. So on the top of the bill, we would write acceptance, on the other side a reverse, where everybody has something different they're comfortable with. We're sticklers about words, so we have many different ways. We prefer to write things on the back of the bottom where the money order is. We write money order on the reverse, on the back of the 1040V voucher. On reverse, we never send them a single blank page, because I've been in a courtroom situation and I've seen it. The judge sitting up there on the bench saying to himself, I'm looking at a blank piece of paper. We idiot-proof everything we send to the IRS. Excellent, excellent advice in any event. All right, moving along. She says there's some interesting stuff. We're now on the top of page 5 that we have not actually tried. We only sign the front and back and put on the back C reverse just so there isn't a blank page. Towards the bottom of that page, she says, we never stamp anything ever. So what she's referring to here is instead of printing it with a printer, which is the way we stamp stuff, she's strongly suggesting to not use that. Well, let me finish. It says we don't do anything that is not handwritten. It's the highest form of affidavit. You're handwriting. You're showing that you're a living man. You're putting your commercial energy into it. I know it would be really fun to be able to be super lazy and just whip out a stamp and stamp everything and turn it into money. By the way, she's gotten that. That's the whole point. That's what you're doing. But I haven't seen anything but handwritten money orders and handwritten acceptances work. That's valuable. That's very interesting. And that's one of the good things. When you're working in a group like that and you're processing a lot of different things, you can actually begin to notice things like that. Whereas if you're just doing it by yourself, you could be doing it for years and never get that. You never figure that out. So what she's figured out is something very valuable, and I think that's something we can apply. She goes on to say you can look in court records and stuff where people are settling cases and people have gotten out of jail, things like that. You look at all the documents. All those money orders are handwritten. All of them. Everything is handwritten. Okay? No IBOEs or bonded PNs, only money orders. We already know that the money order works, so why use anything else? I agree with that, especially with regard to IRS. Okay, now I would not necessarily agree with that across the board on everything, but certainly on IRS, that's true. Okay, now we're at the I'd say a paragraph down below on page 6. And at the top of the page it says processing of payments, and this is an actual IRS document 5.4.1.8 on processing payments, and it says, number 2, before remittances and tax returns can be shipped to their aligned service center, they must be perfected. So the suggestion here is item 1, examine each remittance to make sure it's negotiable and look for the following. A, payer's complete signature, however unsigned checks can be submitted for processing. B, valid date. If undated, enter the IRS received date. If check is post-dated, it should be returned to the taxpayer if the date exceeds 10 days. That's interesting. Numeric and written amounts should agree. Pay should be United States Treasury. Now, why are those highlighted and why is that important? And that was towards the bottom of page 6. And the answer is the money order approach that she and her group have been taking has been based on actual research, which is the balance of this complete package PDF. In other words, pretty much from this point forward is all of the research that she herself has dug up and then has modeled her approach using this research to make certain everything is in compliance. Okay? So that's why there's so many pages here, because it will give you a clue, and once again, I recommend that you actually read this. It will give you a strong clue as to what their requirements are and what they're looking for, okay? The fact that she's applied all of this stuff and has actually seen a lot of success is something that should not be ignored. All right. Now, a little further down on that page, page 7, it says acceptable remittances, and then, of course, cash, money orders, cashier's checks, personal checks, blah, blah, blah. But money orders, of course, is highlighted. And then on the top, or towards the top of page 8, it says review of non-cash remittances. Number 1, to ascertain negotiability, examine checks and money orders for the following. A, payer's complete signature. Unsigned checks should be returned to the taxpayer for signature. B, valid date. If a check is undated, enter the IRS receipt date, etc. C, numeric and written amount should agree. And then, of course, payee should be United States Treasury. All right. So that is it for the most part. Once again, I exhort you to read through all of this. There's some there's some issues for the UCC Article 3 negotiable instruments in here. That's starting on the bottom of page 9. I would actually read all of this stuff. Even if you breeze through it, you're going to find it helpful because it will reinforce what you should already know. And if you don't, then read it more carefully. All right. Enough of that. Let's go ahead. Yes, go ahead. What was the question?
Just a couple of, you may not know the answer, but 3 quick questions on the process. You know, oftentimes you get duplicate mailings in the same envelope, or I've gotten them in duplicate envelopes, the same billing.
Sure.
Does she return each set the same way?
No. As a matter of fact, that's a great question. No. Here's why, and here's what you can look at. All that is incumbent upon you to do is to zero the account. The account is identifiable through a number. So if you have duplicate paperwork on the same account, you don't need to satisfy that account twice. So I think that's pretty clear. However, and this is also important, that's not to say you will not be using that paperwork subsequently, so I would never throw it out. I would keep it. I'd make a note to myself that it's there to remind myself that if this one does not go through, or if this one is not properly processed or whatever, I've got a fallback position. In fact, what we've been telling people is if you're concerned about using the only coupon you've got, because, hey, this is it. Once this is off, I don't have any more coupons to use, then it's not a bad idea to make an actual copy, try to go to a paper place, get the same paper, like an office supply store. In other words, try and duplicate the paper, and then when you actually duplicate the paperwork with the coupon, make sure it's duplicated front and back, and that it literally looks as you can make it, because if you need to use that again, you could. So, good question.
Another question. I've been involved with processes where they said to send in the 1040V blank, but I'm guessing she fills it out to match the money order?
Yeah, the 1040V is left mostly blank, but is not ever blank. And the reason it's not blank is you need to identify the account. So that is the Social Security number and the strawman name. So as long as you have the strawman name and the Social Security number on that 1040V voucher, you can effectively leave the amount blank. The people at IRS will fill that in for you. In fact, if you're concerned about that, put a Post-it note. Tell them, please fill in the appropriate amount.
Okay. And then she says, too, when you go mail it, to insure it, normally you pay so much insurance by the value of the package. Let's say I'm sending in a $10,000. How much do you insure it for, do you know?
Yeah, you have to make up your own mind there as to what you want to do. The main reason she'd like that approach is gaining the witness of the post office, which can be gotten, frankly, without paying some large amount of money for insurance. So, I would take that with a grain of salt, and I would not pay the insurance if it's exorbitant or if it's more than you want to pay. But I do like the idea of backing yourself up. For example, one of the things we did for years was using a third-party affidavit of mailing. And I got so much flack and feedback from people saying, well, I don't know anybody, that we finally came up with an approach to use the post office as your witness by buying postage on the mailing certificate and then having someone hit it with a bullet stamp. And as was pointed out to me, each clerk's bullet stamp is unique to them, so therefore it is the equivalent of a clerk's signature.
Okay,
so
one more question about the duplicate mailings. I've got several of them stacked up here where they started at 5. I got 5, and then I got the updated one with 50, 5,000 plus the interest. Now I'm 10,000 plus the interest.
But you always want to go with the latest one. Go with the latest one.
Just the latest one?
Yes.
Okay.
Yes.
All right.
Always save the other ones just in case you need them later. Right.
Okay.
RJ,
Thank
this
you.
is Sandy.
Yeah, go ahead.
If duplicate mailings are coming about any kind of thing in an unreasonable amount of time, such as the same day or 2 days apart, isn't that harassment? I mean, is there any other category you can put it in? Because this is happening in another area.
Yeah, you can call it harassment. It could also be a clerical error. That's conceivable, except for that goes out the window if they're doing it repeatedly.
Yeah, they're doing it repeatedly, and, of course, it's extremely annoying, plus phone calls.
Yeah, I agree. I mean, anybody who is dealing with IRS problems will tell you that I'm sure it's driving them up a wall. All we're trying to do here is exhort people to do the best kind of administrative process to settle in advance whenever possible. I mean, when you understand that you can actually settle with a money order and you don't have to dig into your own pocket, then what is the conceivable reason for not settling? And the reason I bring this up is the IRS will tell you in advance what their criteria is for handling your complaint. And here it is. Pay first, and then we'll let you complain. Well, for a lot of people who think FRNs are money, that's just not, a viable way to go. They just don't want to shell out thousands of dollars in order to complain, so they don't do anything. And what is that? That's a dishonor. So we know better. We know that a handwritten money order will work, so therefore there's no excuse not to settle every bill as it comes in. I would. Because then, according to their own rules, they have to entertain your complaint. Would it be a viable thing to complain about any illegal practice or even questionable practice? And the answer is yes, and here's why. This is a two-way street. As we established in a previous call, in the demand for assessment call, that when you understand that the IRS is bound by Title 15 FDCPA, Fair Debt Collection Practices Act, and that they are in point of fact a debt collector, then you begin to realize, hey, they really are operating in commerce, and what's to prevent me from turning the tables on them, slamming them up against the wall, and having my way with them by using the rules of commerce myself? And the answer is nothing is standing in your way. Do it. By all means, do it. But by the same token, be careful, because, your time is crucial. You can't just frivolously waste your time because, when you do that, what you're really saying to yourself is this is all hopeless, this is going to go on forever, and all you're doing is discouraging yourself. What you want to do instead is you want to say, look, this will be over, but it's going to be over a lot faster if I handle this correctly. And that applies not just to the defensive, where we're sending the money orders and stuff. It also most especially applies on the offensive, where we've taken the time and the trouble to turn the tables, and now it's time to be meticulous and do the notice of fault opportunity to cure, default, through a notary, written to the public record, do an ICC, and go after the parties involved, specifically the agents and even especially the commissioner. So yes, good idea. Just don't be haphazard about it. Get a plan together and follow through, and make sure the follow-through is everything. If you're going to be the creditor, you better be convincing. It's all about credibility. If there are no other questions right at the moment, there's a few other things I need to wrap up on this, and then we've got other stuff I'm trying very hard to include on this call, if at all possible. I sent a follow-up email. Pardon me?
I have one more question.
All right, go ahead.
In doing this process, was there any success expressed with doing it as a third party for a mother, a parent, a son, or a daughter? No, but I happen to know that has been done successfully. And as I've said to people in the past, is there any law that says you can't pay your mom's bills? And the answer is no, there isn't. There absolutely is not. Okay? Thank you.
Let's continue, because we need to wrap this up. Like I said, go ahead.
Yeah, this is Jack out in California. What if
Hi,
we don't
Jack.
have the original envelope from the IRS?
Yeah, well, I mean, it's nice to be able to use their envelope, but that's not crucial. All she's saying is if you can, any window envelope would be fine, or just handwrite the address that, it would be going back to anyhow. So I wouldn't get hung up on the envelope.
Okay, well, all right, good. Thanks for answering the question.
You bet. Now, we're on page 13, and as you saw earlier, the header said UCC. So 3-104 here, negotiable instrument, is referencing what we were just talking about, and it says, A, except as provided in subsection C and D, negotiable instrument means, and this is crucial, means an unconditional promise or order to pay a fixed amount of money with or without interest or other charges described in the promise or order if it, 1, is payable to the bearer or to order at the time it is issued or first comes into possession of a holder, 2, is payable on demand or at a definite time, and 3, does not state any other undertaking or instruction by the person promising or ordering payment to do any act in addition to the payment of money. And then lastly, down there where it says B and C, B is instrument means negotiable instrument. C, an order that meets all of the requirements of subsection A except paragraph 1 and otherwise falls within the definition of check in subsection F is a negotiable instrument and a check. Now, my recommendation is to memorize this stuff right here, because there have been so many aborted and screwed up attempts to settle accounts because the people that were doing it were putting together instruments that were not, in fact, negotiable. And it went right over their head because they really didn't get it. They didn't understand what they were doing, and they didn't understand what the requirements are. So, one of the things I like very...
If the promissory note as being negotiable because it goes with conditions?
Well, that is the whole point. Thank you. That is the point. First off, you got to understand something. One of the reasons we introduced the escrow agent package was to introduce as much credibility into the transaction as possible and to demonstrate on the face of the transaction that they did not know what the agent was holding for a fact. All they knew, the agent was holding cash or a certified check. How do they know? They don't. Okay? So in this context, absolutely. When you're dealing with IRS and or you're going to do a money order, you have to follow these very explicit directions for the simple reason that Otherwise, it's likely that your instrument will no longer be negotiable. And I want to tell you one other thing just to make it really clear. We're looking at the front end of this. We're not looking at the back end. Do you think that the back end, that the government is actually getting the funds? I'm here to tell you, I know they are. I know they are. But are they going to get it in every case? And the answer is definitely not. And that's why this becomes so important. Because, I mean, if you really get this and you understand that it has to be negotiable, it has to be straightforward, and so on and so forth, then that's what you need to adhere to. Now, let's take the obverse of that just to make it really, really clear. Does that mean under no circumstances can we ever do conditions? Absolutely not. Absolutely not. It's in the nature of the contract. It's in two parts. And here's how it's done, just to make sure that you understand where I'm coming from. In your contract, you can negotiate any terms you want. I mean, within reason. But I mean, one of the terms that we love, don't we, is that if you don't respond to such and such a date and you go into default, you agree to grant me power of attorney. That's a condition. That's a term. Okay? So, okay, let's take that to the next step. Let's say they do default and all of our terms by their silence have been accepted. Okay? Does that mean that if we had an obligation somewhere along the way to pay them, that instrument shouldn't be as is described in Section 3-104? And the answer is no, it should be. So, but it's you see the difference? It's two different things. If you want terms, then stick them in your freaking contract. Nail them down first, and then handle, the negotiable instruments separately. Do not mix the two is really the advice I'm giving you here. But in the case of IRS, you never want to do that anyhow, because you're literally turning their instrument, their coupon that they're sending you, into money, aren't you? Okay? All right, we're coming up on 10 minutes before the hour, so I really have to go through the rest of this very quickly, because I do have a few things to say about the link that I sent you. Let's scroll down to page 29. And it's 3-401. Signature, it says a person is not liable on an instrument unless the person signed the instrument, or 2, the person is represented by an agent or representative who signed the instrument and the signature is binding on the represented person under Section 3-402. And then, of course, under 3-402, it's signature by representative. And this is kind of interesting. If a person acting or purporting to act as a representative signs an instrument by signing either the name of the represented person or the name of the signer, the represented person is bound by the signature to the same extent the represented person would be bound if the signature were on a simple contract. Very, very interesting there. So, and then lastly, if a representative signs the name of the representative of an instrument and the signature is an authorized signature of the represented person, the following rules apply. I'll let you read that on your own. And let's scroll quickly down to, I think that's it. Hang on. Yeah. Payable to bearer or order is 3-109. That's on page 50, I think it is. Yeah, 50. And then, of course, 51, we already went over the sample. So that will, and then, of course, on page 53, you've got a sample 1040V. And that's it. And that takes care of our complete package PDF. Let's now turn to, please, a document which you probably don't have, which you will be able to download. What I did was I initially tried to send it, and I realized what an idiot you are. It's not going to work. You're trying to send a 10-megabyte document, and so I realized that that wasn't going to work. So I went ahead and I uploaded it to the ZD_CONF_calls folder, which you guys have been accessing. You've gone to that folder and then audios.html. I will also be listing it on the audio's page off of today's call. And the name of the document, as you will see on that page, and I've also given you a link in the email address as well. But you will see it's called...
Work.
Go ahead.
The link doesn't work.
Not yet. It's still... Will you believe this? It's now just finished transferring, just this minute.
Okay, thank you.
Okay, so TK outline 4-25-09.pdf is now there, and I will be listing it on audios later on today. I just want to briefly go over it now and give everybody a little bit of background on this because we've been working on this stuff, if you like, since, January, when I went up to Cleveland. And I can tell you that it's a very promising approach. And it's not that I haven't liked this approach. I've liked it from square one. And it's not that I don't want to use it. I do want to use this approach. I like it very much. But I've been very concerned about several things. The first one is there was nothing explicit. It was nothing very carefully and explicitly explained. Everything was very loosey-goosey. Tony was saying one thing in one place and saying something else later. And, my BS meter was just going off all the time. So I don't like that approach and stuff like this. You have to be very, very precise. Or if you can't be, then you have to say, well, maybe I shouldn't be using this. All right. Here is what I'm not going to go over everything now because it's coming up on the hour anyhow, but this will be available for your download. And if everybody would like to go ahead and take notes, I would like to explain what it is and how you can use it. All right? All right, number one, these are the GSA forms. We've already covered them before. What the problem was that there was nothing explained in great detail in terms of how to fill it out, when to use it, under what circumstances, what to use it with. In other words, making certain that you were doing absolutely everything correctly. And considering the number of pitfalls or places that people can go astray, get screwed up, the last thing you want to do is have, directions that aren't, very easy to understand or just bad. And if that's the case, and that was the case in my opinion, then, it makes the whole process unusable. This is as a result of other parties getting involved and getting clear, understandable explanations, and then going ahead and inserting them wherever they could in all the various blank spaces to make it as clear as day exactly how to fill out each form, exactly how to use it, which forms should be used with other forms, and so on and so forth. Now, write this down. This is important. If there are certain people I know, whether they're on this call or not, who have been so overwhelmed and are getting so beaten up by the IRS that it does warrant, in my opinion, going ahead and taking the small risk of actually using these forms. Other approaches have been used, and at this point, the bleeding is so extreme in some cases that, we need to stop the bleeding and we need to get these guys cut off. And these forms, when used with IRS, have been very successful. So, that's the case in which I'm recommending them. Do I recommend to use these forms in other cases? At the moment, no. Does that mean I won't change my mind or that we won't be further enough along to be able to use them in other cases? And the answer is yes, we probably will, just not right this minute. The most important and the most pressing need that I've seen in our members, frankly, has been IRS-related. And that's why I'm saying anybody who is getting absolutely clobbered by IRS, who absolutely must have relief, I'm recommending that they use these forms. I am also recommending that they first do a short administrative remedy which I will work with anybody who needs to use these forms to put that together so that you can get a power of attorney so that you can go ahead and properly fill out the standard form 1402, which is the certificate of appointment for a warranted contracting officer. Okay? Now, what forms are going to be used? The first page, when you get this document finally, you will get it later on today, is standard form 28. That is always used. All right? And the instructions on that are quite explicit and extensive. All right? The next form is a appointment of attorney, a verified appointment of attorney. And there, once again, that's filled out in a fairly explicit fashion, and you can use that. And then the next form is the release of personal property from escrow, which is the optional Form 91. And once again, there is plenty of direction here to explain the situations where a optional Form 91 would make sense. In most cases, which you will discover, is that a Form 90 will be sufficient and not a 91. In other words, you don't need to use both 90 and 91. And, oh, by the way, the other use, I mentioned IRS, that I strongly recommend, and we're going to go ahead and use this for a couple of guys that are currently in jail, is release of prisoners or inmates. So that's another very, very good reason to use these documents. The other reasons, such as, mortgages and stuff, we're not there yet, and I would not jump on that bandwagon yet. In any event, my recommendation across the board is that everybody, when they get this downloaded, print it out entirely and read through everything and get very familiar, first off, with the forms themselves and with the directions. Take notes, write notes to yourself in terms of how, things you're observing or things, questions that you have or whatever, because we will be covering these forms with their directions in some depth in a future call. But for now, anybody who has a big IRS issue or is being bled dry or what have you that needs these forms now, simply send me an email to zerodebts@rocketmail.com and let me know of your interest in using the TK outline forms, the GSA forms. And I'll be happy to either put together a small call to go over it with everybody or to help you actually get these filled out and, used. So this is another way to handle things that, if your back's against the wall and you need immediate relief quickly, this looks like probably the best approach. Both of them, what we covered today, are, both good approaches and should get the kind of relief we're looking for. It's now 4 o'clock. Any questions just on what we've covered today, please? Anybody have any other questions?
Hey, RJ.
Yes.
Yeah, I got a quick one. I've got an IRS frivolous filing, and they captured a return. How would this apply, and would it apply? Because I actually have the voucher and the penalty form. Okay. So I would go with Catherine's approach first. Okay. I would definitely go with Catherine's approach first, but in the same time, I would definitely start reading through this material, getting the forms. You can download them right from GSA, and go ahead and, following very explicit directions here, go ahead and fill them out. You can have them sort of waiting in the wings, but I would give Catherine's approach a try first. Always remember, if you want to dispute with IRS or if you want to lodge a complaint, always pay them first with a money order, always. Okay. See, then you're not in dishonor. And honor dishonor is everything. That's everything. Everything we do,
all of our little administrative remedies and how we can win and everything, all of that, the foundation is honor, dishonor, which means we stay in honor, we trick them, if nothing else, into dishonor. And it doesn't take much, because there are very dishonorable people anyhow. But we want to get our opponents into dishonor. We personally want to stay in honor, and that is so fundamental to everything we're doing. So never overlook that. Hopefully that answers your question.
It does.
Okay, good. Anybody else have any questions about what we covered today? Excellent. Okay, I'm sorry. Go ahead.
Can you hear me?
Yeah.
Oh, because I was on. Okay. When you talked about a negotiable instrument not have any terms or conditions, do you think that may be a reason that some?
You got cut off. Do I think that may be the reason that what?
Some of our promissory notes have not worked because they all say lodge for up to 18 months at 7%.
Yeah, as a matter of fact. Exactly.
Condition.
Yeah.
So those promissory notes should not have anything like that. Just pay and no interest.
Well, yeah. If first off, today we were dealing principally with IRS, and what the consensus was from Catherine's group, and I agree with her, is why mess with anything other than a money order when money orders are working? And that's a great point. Now, when it comes to other issues, what I said to Bruce earlier actually does apply. There's no need, in my opinion, there's no need to put conditions into the instrument itself, but especially considering the fact that you can get them into a self-executing contract where you can have all the conditions in the world that you want. Not a problem. See? And the other way we're getting around things, just so everybody's clear on this, is with the escrow agent package. Because the beauty of the escrow agent package is when you pay the escrow agent, guess what? You've paid. And then secondly, there's nobody, witnessing the kind of instrument or whatever. And what did the escrow agent say? Yeah, I got legal tender funds here. Why did he say that? Because he's been tied down with a contract. He's agreed that your instrument constitutes legal tender funds. So he's going on record for you saying, I'm holding legal tender funds. Well, how does that make the bank look when they don't pony up the note? It makes them look terrible. It makes them look like the crooks that they actually are. So hopefully that helps.
Yes, thank you.
Any other questions today?
This is Vince from Oregon.
Hi, Vince.
Hi. I called you this morning to let you know that information I sent you last night was from that woman's website.
Yes.
It was supposed to be good material.
Yes.
Okay.
Thank you for that. I appreciate that. Anybody have any questions about what we covered this afternoon?
RJ, Larry?
Go ahead.
What if the last statement like you got from the IRS about what you owe is like 4 to 5 months old? Should you try to call them and get an updated one, or just...
Excellent question. Here's what I would do based on what Catherine has observed. It would be better. Let me put it this way. If you got a bill for $10,000, and in actuality, the updated bill is $10,086 and change, doesn't it make sense to use what you've got and settle the $10,000 right now?
Right.
And then if they want to come back after you for the 86 and change, when they come back with another coupon for 86, you can settle that one. That's what I would do.
And one more question.
Go ahead.
With my stuff at the state,
yes.
There is no 1040V voucher with this, so I don't send nothing else back except for my...
Oh, excellent question. Thank you so much for bringing that up. That's excellent. I love it. Anybody want to tell Larry whether a 1040V would be an appropriate form to include on a payoff at state level?
Oh, I know what your answer is going to be.
Yeah, the answer is yes.
Yeah, after talking to you yesterday, I just put it together, yes.
Yeah, it's a good idea always to do that.
So grab one and put it in there with it. Okay. Thank you.
You bet. Anybody else have any questions about what we covered today? All right. Listen, it's coming up on 10 after the hour, so everybody have a great afternoon. We will have another call on Tuesday of next week. We will be following up for everybody who is interested in or has found, expressed an interest in joining the class action that John has, we've got some fairly exciting developments. Last Tuesday, we covered how to put together, from the ground up, a proper complaint. We have subsequently talked to some people, and what we have determined is that unlike John's approach, which was very good and it worked, he ended up with a nihil decent judgment, so that's very good. What is better is, and if anybody has got a notepad and a pen, jot this down because you don't want to forget this. This is really cool. What's better is to go ahead and use your administrative remedies in advance. Do notice fault default, when appropriate, always through a notary acceptor. Write it to the public record. This is called an administrative judgment. And if you can get more than one of these, to involving all the appropriate parties, then when you bring your claim, your complaint, as a part of the class action, you can actually do so as a declaratory judgment. What does that mean? It means the time for argument's over. They are stopped from saying a word. They had their chance. And so that is, I'll tell you what, I'm dealing with a number of cases right now where I wish to God, as time went by, the people involved were on top of that, because that's the magic. Can the court deny you a declaratory judgment? Yeah, they could. Do they have any basis for doing that? And the answer is no. Not if you've taken care of business. In fact, what's cool is right in the Rules of Civil Procedure, it outlines the requirements for a declaratory judgment. So if you've met all the requirements, how does the judge get off saying no to you? And if he does say no, and this is even better, in cases where you've got a counterclaim and they're bringing a claim against you, how many times is their claim actually backed up with the subject matter, i.e. the note? And in mortgage cases, rarely. Here in Florida, it's rampant. The number of cases coming into court saying, oh, well, we lost the note. Please reinstate it, Your Honor. Well, gee, do they qualify? No. Did they even read 71.011? No. They haven't. They don't care because they know it's all a scam and everything's rigged. At least it usually is. So, in those cases, it makes all the sense in the world to, before you ever come into court, make sure you've won in advance. So I highly, highly recommend that for everyone. I guess that's it. It's now 10 after the hour. Thank you very much for everybody for joining us this afternoon, and we will be seeing you next week. And don't forget to download that TK. We did send you a link to download it in the email, and we will be including a download link in our audios.html. Have a good afternoon. Bye-bye.